Hello, everybody. Welcome to Joe the Lawyer. Today, I want to take a look at a couple of news stories here. I'm going to combine them both in a live stream. We're going to look at the armorer for Rust. Rust is the movie set where Alec Baldwin had a prop gun go off that shot two people and killed one. Then we're also going to take a look at why people shot by Kyle Rittenhouse in his trial can be called rioters, looters, and arsonists, but not victims at trial. A very important decision from the judge. So let's start off here by reading this story, New York Post. And if you like my content, please like, subscribe, comment, and share. I am a practicing criminal defense attorney in Pittsburgh, PA. I also do personal injury, family law. I provide a legal perspective on legal news. Rookie Rust armorer once made Nicolas Cage storm off film set after firing gun. A furious Nicolas Cage stormed off the set of a film where Hannah Gutierrez Reed was in charge of weapons and ripped the rookie armorer for firing a gun without warning, crew members said in a new report. The 24-year-old Rust armorer in charge of guns when Alec Baldwin shot dead cinematographer Helena Hutchins last Thursday, was repeatedly accused by crew members of breaking basic safety protocols on the Montana set of Cage's The Old Way in August. Cage even walked off set screaming at Gutierrez Reed after she fired a gun without warning for the second time in 3 days, the movie's Key Grip told the outlet. Make an announcement. You just blew my effing eardrums out, Cage yelled before walking off in a rage, Brumbaugh recalled. I think it might actually be cool to get yelled at by Nicolas Cage. Am I right? Brumbaugh even told the assistant director of the armorer she needs to be let go, he recalled. After the second round, I was pissed off. We were moving too fast. She's a rookie, he said, saying that it was only after complaining that he found out that it was the key crew member's first movie in charge of weapons. Let me ask you, what are the qualifications for an armorer on a movie set? Brumbaugh detailed a series of complaints that were made about Gutierrez Reed, including that she walked onto the set with live rounds or blanks without announcing it to the cast and crew. She also walked around with pistols tucked under her armpits such that they were pointing back at people and allowed firearms to be aimed at people, Brumbaugh told the Wrap. Oh, well, hey, I'm just going to take a couple guns, put one here, and walk around the movie set. Hey, everybody, how you doing? Not cool. Another crew member who spoke on the condition of anonymity confirmed the concerns. Gutierrez Reed put the cast and crew in several unnecessary and dangerous situations. I understand, Archangel, the armorer was no weapons expert, so why is she the armorer? That's a question that I believe I have an answer for. Before the fatal shooting on Rust, Gutierrez Reed, the daughter of a Hollywood weapons expert, Tell Reed, had admitted not feeling ready for taking on responsibility when offered the Old Way job. It was also my first time being head armorer. I was really nervous about it at first, and I almost didn't take the job because I wasn't sure if I was ready, she admitted on a podcast last month. I think the best part about my job is just showing people who are normally kind of freaked out by guns how safe they can be and how they're not really problematic unless put in the wrong hands. Well, the sad thing is that you've ended up feeding the exact opposite narrative, right? Because now what happened here is going to drive fear about firearms. Brumbaugh blamed movie producers for putting such inexperienced people in key jobs just to save money. There we are. It's been happening more and more as producers refuse to bring more experienced people because their rates are higher. They demand we take our time, and producers don't want to pay it. So they hire a newbie who is energetic and wants the job and will do it with less people. More than Gutierrez reads in experience, he believes the problem on Rust was that she did not have help. Brumbaugh said, echoing complaints from other experienced movie crew members. She was doing everything by herself in that movie and on the other movie. And here we go. There's Nicolas Cage looking very dapper as a 18th century Amish person. Oh, no, maybe not. Okay. If there was more than one person in the other movie, the tragedy wouldn't have happened. A second person would have inspected to make sure the barrels were clear. Well, do you really need two people? Do you really need two people to inspect? I mean, I really think one person's enough, as long as that person always inspects. Gutierrez Reed could not be reached, and neither the first assistant for the Old Way nor reps for Cage responded to requests for comment. One unidentified producer on the movie did, however, insist that they had no such recollection of the events, the Grip mentioned, insisting they were being blown out of proportion. Jeffrey Crow, the prop master who supervised Gutierrez Reed on the Old Way, also defended her in a recent interview with the LA Times. I thought she was an exceptionally young, up-and-coming, very eager, and talented armorer, he said, saying he was stymied that she could be involved in the accidental fatal shot fired by Baldwin. Here we go with some pictures. I had a lot of faith in her, and I still do. I'm going to be surprised if there was anything she was ultimately responsible for in all this. Just seeing how she acted in the past, this is all such a surprise. Well, here's one thing that I will say based on what I've read, okay, is that, the assistant director took this gun, said it was a cold gun, and handed it to Baldwin. Now, where was the armorer during all this? And did the armorer tell the assistant director that this was a cold gun, or did he just make an assumption and grab that gun? Okay, if so, that part of it is more on him. However, the reports from what I'm reading is that the guns were on this cart, and the cart had blanks and live ammunition. It had the fake ammunition and the live, it had blanks, some other type of ammunition that I'm not familiar with that's used on movie sets, plus the live ammunition. Why is that getting mixed around or allowing that to get mixed around? That sounds to me like that's the fault of the armorer. Finally, my theory is this, and I think I read a little bit about this, but what we have going on today is more and more movies and series are being produced than ever before, right? Because you have television, you have Netflix, Disney, Hulu, Peacock, and then you still have large Hollywood films that are going into movies. So I believe what's happening is that the resources of Hollywood movie production are being spread thin, and more movies are being made on smaller and smaller budgets. And that's what happened here. And you hit it, Zephiel. You always want to save money with firearms. That's exactly what you don't want to do. When you have firearms involved, you spare no expense. There is no excuse for this woman, in my opinion. She had one job. Oh, man. Woo. You got to. When it comes to firearms, you have to. Couple other developments in the case. Apparently, Alec Baldwin has been cleared to leave New Mexico. That may mean that charges aren't coming against him. I believe the charges would likely be justified based on just the facts that I have now. As more facts come out, the situation changes. My opinion can change, but it seems to me that if the district attorney and law enforcement are letting him leave the state, then he's probably, it looks like he's not going to get charged. I'd be shocked if the assistant director and or the armorer don't both get charged. And perhaps we don't know everything in this case, so there could be some other third party who should be getting charged here. In addition to that, I'm trying to think if there were any other developments on the case. No, that's about it. I wanted to share this story about this armorer, though. It just totally makes sense. Yeah, negligence, possibly. Look, there's going to be civil lawsuits. Maybe the family of Ms. Hutchins doesn't want to press charges, okay? There's going to be lawsuits, no doubt. But as far as criminal, I don't know. I do think that they should really, really look hard at this and possibly pursue some charges. Okay, let's look at our next story from today. Okay, people shot. I think this story came out, a couple days ago. October 27th, yesterday. Here's why people shot by Kyle Rittenhouse can be called rioters, looters, and arsonists, but not victims at trial. All right, here we go. A Wisconsin judge presiding over the upcoming trial of Kyle Rittenhouse has ruled that prosecutors cannot refer to the 3 people shot by the teenager last summer, I'm getting over a bit of a cold, as victims. However, the defense may refer to them as arsonists, looters, or rioters if they can prove they participated in those activities. Very interesting. Kenosha County Circuit Court Judge Bruce Schroeder made the decision Monday at a pretrial hearing where the parties debated several issues ahead of next week's trial, including permissible terminology, witness accounts, and evidence. Schroeder said he wouldn't prevent the defense from calling those who were shot such language if the defense can produce evidence to back up the claims. Prosecutor Thomas Binger reportedly called the decision by Judge Bruce Schroeder a double standard. However, barring the term victim at trial is not necessarily the norm, but varies from courtroom to courtroom at the judge's discretion, according to Keith Finley, a professor at the University of Wisconsin Law. Finley explained the judge is differentiating the facts of the case from the questions the jury must answer. Since Rittenhouse is claiming he acted in self-defense, the question is not who shot 3 people, killing 2 of them, but rather if Rittenhouse was justified in defending himself out of fear of bodily harm. If his lawyers can show he had reason to believe the men were each engaged in activities such as looting, rioting, and arson that could sway the jury to accept Rittenhouse's defense. Well, that's a very nuanced view. On the other hand, it still is prejudicial because it runs the risk of signaling to the jury or inducing the jury to decide the case on a matter that's not really appropriate or relevant, and that is whether these were bad people or somehow less deserving of protection from the law, Finley told CBS News. There is some risk that using loaded words like that will induce the jury or make it more likely the jury decides the case on an impermissible basis. Very interesting here. Under Wisconsin law, the charge of first-degree reckless endangerment of safety requires prosecutors to demonstrate the defendant acted with utter disregard for human life. With rulings like these from the bench, Finley says the state is facing an uphill battle toward conviction. Okay. Prosecutors can use other terms when referring to those who were killed and injured that night, such as their names, decedent, or the deceased person Rittenhouse shot. That's just a straight factual term. Judge Schroeder also decided to allow the defense to show the jury a video taken prior to the shooting, which shows police telling Rittenhouse and other armed militia members on the streets that night that they appreciated their presence in tossing Rittenhouse a bottle of water. They argued that it shows their client was not acting recklessly that night. Interesting. However, prosecutors argued the video would turn the trial into a referendum on police procedure that night when it isn't relevant. This is a case about what the defendant did that night. I'm concerned this will be turned into a trial about what law enforcement did or didn't do. Judge Schroeder disagreed. If the jury is being told if the defendant is walking down the sidewalk and doing what he claims he was hired to do, and police say, "Good thing you're here," is that someone influencing the defendant and emboldening his behavior? That would be an argument for relevance, he said. While videos like this can be permissible, Finley notes they risk influencing the jury about the relevance as to the police's opinion of whether Rittenhouse's presence was justified. The problem here is that while this evidence may have some limited relevance, it also has very substantial risk that it will be misused, and therefore that's a form of prejudice. Well, I'm going to make this point of mine right here. You also have to take into account that in the United States right now, there's a very high level of skepticism and negative attitudes towards the police that haven't really existed in this country before. And if Rittenhouse is seen as associating with the police in an odd way, this could help the prosecution. This could help the prosecution. I'm not so sure that evidence of him, the video of him catching a water bottle and having this conversation with police helps him. It may help him with some jurors, but I really don't think it would help him with all the jurors. There are going to be some jurors on there that are going to think less of him because he was buddy or approved of by the police. So I'm not so sure that evidence hurts the prosecution as much as they think it does. Rittenhouse, who was 17 at the time, was charged as an adult with 2 counts of first-degree homicide, 1 count of attempted homicide. He's also facing charges of recklessly endangering the safety of 2 other victims and possessing a weapon while under the age of 18. He has pled not guilty to all charges. Prosecutors allege on August 25th, 2020, during the night of protests over the police shooting at Jacob Blake, a 29-year-old black man who was left paralyzed, Rittenhouse fatally shot Joseph Rosenbaum and Anthony Huber and wounded a third person with an AR-style rifle. I'm not going to go into the facts. I think everybody's familiar with them, okay? And you guys can go ahead and read this. The interesting thing here is the decision by the judge. So, the judge is saying that if there are facts that are presented at trial that show that the individuals who shot were rioting, were engaged in looting, or were arsonists, then they can be called arsonists. I'm with that decision. It's definitely prejudicial. If I were the judge, I would reserve my ruling to see exactly what happens in the trial. Because but here's the thing, if that evidence doesn't come up, they won't be able to be labeled that way. Now, the word victim is a bit more complicated, in my opinion. Has ruled that prosecutors, barring the term victim, is not necessarily the norm. It's the problem here may be to have some limited relevance. It also has a very substantial risk that it will be misused. Victim seems a bit more complicated. Let me go back to some of what was said here. Finley explained the judge is differentiating the facts of the case from the questions the jury must answer. Since Rittenhouse is claiming he acted in self-defense, the question is not who shot 3 people, killing 2 of them, but rather if Rittenhouse was justified in defending himself out of fear of bodily harm. This is a tougher one. It runs the risk of signaling to the jury or inducing the jury to decide on a matter that's not really appropriate or relevant. There's risk using sort of loaded words like that will induce the jury. Well, how about this counter argument? And everybody who's in the room, let me know what you think here. You know what I want to do? I want to see the definition of the word victim. I know this sounds funny. A person harmed, injured, or killed as a result of a crime, accident, or other event or action. I don't know. I kind of think, I think a fair decision here may have been to say, listen, you can refer to them as looters, arsonists, and shooters, but you can refer to the people who were shot as shooting victims because they were the victims of a shooting. And that may be a nice way to split the baby, as King Solomon did. Because I don't think just allowing them to be called victims automatically gives the case to the prosecution. And I don't think allowing these people to be called looters or arsonists automatically gives the case to the defense. the judge must believe that the word victim is more loaded than those other words. But I'm not sure that's true. It may be a little more loaded, but I don't know if it's so loaded, especially when the definition of a victim can fall into someone who was hurt by an accident or basically hurt by any means. This is one I really need to think about. Let's see here. One that is, look at this definition. Wow. One that is acted on and usually adversely affected by a force or agent. Under that definition, look at this cat. Okay. All right. Come on with this cat. You're killing me. Under that definition, they should certainly be allowed to be called victims. Acted on and usually adversely affected by an agent. That is a definition that would fit what happened to them. It doesn't automatically say that Kyle Rittenhouse was not unjustified in this decision. Now, I'm a defense attorney, so, I'm usually going to view things through that lens, but I think a more fair way to conduct this trial would have been to allow both parties to use these terms and then let the jury decide, right? The lawyers are going to get in there. They're going to do their job. That is where I would go. You should watch the defense attorney talk to the judge. He was getting very aggravated withholding decisions until trial. Well, the smart thing is to withhold the decisions until trial because they may never come up. And the context may change once it's brought out in trial. So why make a decision on it beforehand? That was the judge's stance regardless. I think I disagree with the judge here. Maybe in this specific circumstance, I do think courts have gotten away from just allowing people who were damaged by crimes as being called victims generally. Because usually in a context, most people who are accused of crimes don't have a self-defense argument. Okay, they don't have a self-defense argument. Kyle Rittenhouse has that, which helps counteract that labeling of victim. But in other cases, that's not true. So if they're going to get rid of the word victim, I think that courts, this might be something that a president judge in a court or a local Supreme Court or appeals court should deal with in order to create a blanket rule. But if there's no blanket rule in this particular case, I would allow both. Now, I wonder if this judge always keeps out the word victim. Does this judge always keep out the word victim, ex-felon or other terminology? Well, that is terminology that definitely wouldn't come in Zephiel. So you're not going to be able to bring in the defendant's, well, in most circumstances, the defendant's prior criminal history. And you certainly can't use the word felon. The one thing about the words that are in discussion here is neither of them apply directly to Rittenhouse, right? They apply to other actors in the case. So, that's kind of where I fall on both of these. It's going to be interesting to see how it plays out. Thank you, everybody, for tuning in. I know I got 4 viewers, Zephiel, Archangel. Thank you, guys. You joined me from my other channel. So it's nice to see you over here. My voice is a little hoarse and my throat a little sore still, so I'm going to call it a short night. Thank you, everybody, for tuning in to Joe the Lawyer. I have been staying on top of both of these cases. I will continue to watch them. If you like my content, please like, subscribe, comment, and share. Okay, everybody, have a great night. A prosecutor did say he's the only judge that has an issue with certain terms. See, some judges will give a lot of free rein to the attorneys. I honestly, I would, if I was a judge in this case right now, making the decision on what I know, I would let them both use those terms. I really would. So, Bob, thank you for joining me, but I'm calling it, my throat's killing me already. Just a lot of talking today. So, thank you, everybody, for tuning in. I will do some longer live streams coming from me in the future. Okay,